All right, so we're gonna begin with a video. So let me go to um, a video of Congressman Emmer
Okay.
outlining what it is that he's concerned about, which is what our concern is also, as it's going to relate to our the letter that we're going to be writing, and pertaining to issues that will come up eventually. Because when you talk about these enforcement actions, they're a mandate under executive order. So it's something that they're going to be doing on a regular basis. So today it may be Neil that we're talking about, but in the future it could be any one of the thousands of people who have to contend with these independent agencies. So, and that's what we want to get across. It's not just for Neil, although we're using this approach for Neil, and we're considering these things for Neil, but for the most part, it's all purpose for us. So let me go ahead and play this, and then after that, I'm going to explain the instructions a little bit further.
Okay.
All right.
Thank you. We now recognize the gentleman from Minnesota, Mr. Elmer.
Thank you, Mr. Chairman, and Ranking Member Huizinga for hosting this hearing today. Mr. Grual, you frequently acknowledge that public trust and confidence in our capital markets has eroded. In fact, on October 13, 2021, you stated, quote, "The decline in trust undermines the investor confidence needed for the fair, efficient, and orderly operation of our capital markets. Put simply, if the public doesn't think the system is fair, they are not going to invest their hard-earned money." Close quote. I agree. But time and time again, you place the cause of blame for this erosion of trust almost squarely on the shoulders of industry participants and companies. Mr. Grual, the SEC is in no way blameless here. Chair Gensler's political regime at the SEC, carried out by its Division of Enforcement, has been characterized by a focus on using enforcement to expand SEC jurisdiction at the expense of public resources, public investment in our country, and public trust in our markets. It seems clear to everyone, except maybe those at the Commission, that the SEC is not regulating in good faith. Although many sectors of the industry have grappled with the SEC's politicization of regulation over the last 14 months, it can be seen most clearly when it comes to the digital asset industry. Take, for example, industry sweeps. As you know, industry sweeps are not novel to the digital asset industry. They are a series of voluntary document production request letters as a regulator sends to everyone in a given industry who is similarly situated or is involved in the same type of activity. Mr. Grual, does the SEC Division of Enforcement do industry sweeps?
We do industry sweeps from time to time when we have indicia.
Thank you. The answer is yes. I reclaim my time. Are there currently any industry sweeps underway?
So I can't talk about investigations.
You can't talk about it legally, or you won't talk about it?
It's our policy not to confirm or deny investigations.
So you won't talk about it. All right. What do you do if a company, sir, cannot respond to a sweep letter because they're not in your jurisdiction?
If we issue a voluntary request for information, there's not much we can do. We can proceed with the subpoena and then a subpoena enforcement action.
So you do extra jurisdictional requests then?
Voluntary requests are just that. They're voluntary. They're an important part.
Again, sir, I'm not asking about the request now. I'm asking about the people you direct those to. There are some that would be within the SEC's jurisdiction. There are some that are not. My question is, and I think you've confirmed it, that you do industry sweeps to extra jurisdictional market participants, people you do not have enforcement authority over.
We subpoena individuals and witnesses who may be in the market participants.
Are they within your jurisdiction and outside of your jurisdiction?
We're not limited by our jurisdiction. When we're collecting evidence, we follow the evidence wherever it leads and to whomever it leads. There may be someone who doesn't work in the industry who might have information.
I would say, sir,
go after them.
I would ask you, so you do extra jurisdictional work. Some would argue that that's not appropriate. But Mr. Gruol, has Chair Gensler ever directed you, or to your knowledge asked any of your colleagues, to make it a bloodbath for companies who don't respond to a sweep letter, which are voluntary?
No, that's not happened.
Interesting. We've become aware that Chair Gensler has in the past directed the Division of Enforcement to send a sweep letter to a particular sector of the crypto community designed to jam them into a violation that is allegedly unconstitutional. And if any company does not respond to said sweep letter, which I'll reiterate, as you've said several times, are supposed to be voluntary, then the SEC would make it a, quote, bloodbath for them. If true, I imagine such a tactic would significantly erode trust between the public and the SEC. Here's the problem. The SEC isn't interested in clarifying what areas of the crypto industry fall under SEC jurisdiction. We know that because FinHub, that you've referred to, the SEC division focused on crafting crypto regulation, has essentially dissolved under Gensler. Nonetheless, while abandoning good faith attempts to clarify how the Commission's existing authority applies to digital assets, the SEC is hell-bent on expanding the size of its crypto enforcement division and using enforcement to unconstitutionally expand its jurisdiction. Under Chair Gensler, the SEC has become a power-hungry regulator, politicizing enforcement, baiting companies to, quote, come in and talk to the Commission, then hitting them with enforcement actions and discouraging good faith cooperation. Understand, sir, there is a new day coming. Thank you. I yield back.
And it's the reason also why we're doing this campaign, because even though the SEC isn't directly bringing charges against Neil, the SEC has been sending out these sweep letters to members.
The subpoenas.
Yes, the subpoenas out to different groups because they're doing a joint investigation from another side. So it's still part of the same investigation, because it involves Mike and his activities with the groups. So it's important that group members understand why this is important.
But it's just like what he said. Do they have jurisdiction to even do that?
Right, and in certain instances they may have, but in the instance that involves Neil's particular case, what investigation the SEC is doing with Mike Glaspie is they're making it seem apart and separate, but it's running concurrently. So as soon as Neil was arrested, the subpoenas went out from the SEC. And they're really testing the waters, because of the indictment that the DOJ has. It names victims. It gives a number to the of those victims. And there's a difference between those that may have invested directly and those who have pledged collateral loans. So they're conflating these things, which, you know, since we're not being notified that they're doing this on behalf of the group and instead getting subpoenas, it looks as if they're trying to justify the indictment claim. You know, by you know, and here's the issue. I've seen how these are worded, and they're not worded very clearly. So from the very beginning, whoever is receiving them doesn't know whether or not they're a subject, whether it's voluntary, or whether or not they're a witness, or they're just being asked, you know, questions concerning a specific issue, although it's implied. So it's implied at the top in the case involving Mike Glaspie, and then it's addressing individuals. See, that's extra jurisdictional. That's going into the private sector, And that's going into areas of right of contract, private contract, which they have no right to. So hopefully people will be able to recognize the difference between public and private. So after reviewing that gives them a background. Then there's the representative letter template, which is going to be attached. And what we're saying is that when people are doing this, they can do it to more than one representative. If they're from a state like Minnesota or Detroit or some California or some of these other congressional districts, then they can write them directly. But there's also a general email for the Oversight Committee, for the Financial Services Oversight Committee. And we're going to also include that as well. But they can write to more than just one representative. They don't have to just write to one or the other. They can write to this one and that one and this one and that one. And since it is in the template form, all you're doing is just changing out the information, concerning the representative. Okay, so here's an example of the letter. Dear representative, as a constituent. Now this can also be modified. So this is going to be sent in a Word document, so it can be edited. So it says, as a concerned member, as a concerned member, I urge you to support an immediate investigation, dismissal in a case, and it gives Neil's
like the case.
Neil's information. And this is usually important because of the unlawful agency overreach and the joint enforcement actions of the DOJ and SEC pertaining to industry sweeps in the cryptocurrency space. And the defendant is part of, in the process of his Fourth, Fifth, Sixth, and Eighth Amendment rights have been violated to date. So this is the real concern here, is that in the process of doing these quasi jurisdiction investigations and also cases, that they're actually in violation of civil liberties, which is what our concern is. So, and then it goes on to state specific facts. Fact one, defendant is owner of a group of companies operated under the banner of Versus. So, and the reason why we mention that is because as an individual, the accounts that are being forfeited, or they're freezing these accounts, don't belong to the individual. It belongs to the individual within his capacity as an owner. So that's the other issue as well. So those accounts that are listed on the indictment are also connected to various companies. Okay, these various companies make up the deal aspects. In other words, this is what members who did this, the collateralized loans, put their monies forth in order to keep the company operating. So this way it would retain its market value and be able to be sold, and they in return would see the benefit for their collateralized loan. So fact two, is stating the difference between investor and victim. So although there are some that were directly invested into these companies as investors and have a contract directly with Neil or some member of those companies, we don't. Our group, the group's interest is in a collateralized loan. And
Correct.
that is dealing directly with Mike. And Mike is not the subject of the investigation or the indictment. He may be considered a witness or somehow involved, but he's not the subject. So therefore, we don't have a contract with a subject. But what it does do, the DOJ is creating a tortious interference, which means that they understand that there are contracts already out there that by freezing these accounts and going after Neil individually in his personal capacity, that they're actually interfering with the execution of those contracts and therefore interfering with the deal and creating damage and injury. Your support for this issue is critical because your constituents have benefited from the knowledge of civil liberties from the work that you have or are doing on the U.S. House Oversight Committee and the FCC. I would like to request a written response on this issue, and my contact information is down below. So pretty much what we're looking for people to do is fill out their name, address, email, and so forth, and also sign here or place their name here as a signature, and be able to send that out. And that will have an impact because what we're going to end up doing is asking them to also CC their filing. So when they file this, they can go to, they can do it, they can drop it in the mail and just, send us a hard or just a copy of it, or they can actually go to, let me see if I can bring it up here. No. Had it on the email. Let me read. Okay, so this is contacting the financial committee, financial services oversight committee. So this address and email address. So this is where they'd mail it. And this is where they'd email it. It also gives the option to find the individual's representative's name. So if, say you're not from a state that one of the committee members are on, but you wanted to file it through your representative, you can actually find that here. So this page becomes important, and we'll be sending a link to this page as well.
So let's say like myself, I'm in Florida, and I'm going to be filling this out. I don't know, like, Senator Rubio is one of the senators.
Well, what's your zip code?
33026.
Okay, so let's see what's there. Find rep and by zip. Okay. Oh, can you see that on your screen?
No, I can't.
Okay, so it's the 23rd Congressional District of Florida, And your representative is Debbie Wasserman Schultz.
Okay.
So you'd write Debbie Wasserman Schultz and just say, in connection with the Financial Services Oversight Committee. Just wanted to let you know and wanted you to also discuss this with members of that committee, our concerns. You see what I'm saying? And then it looks like it's true for Plantation. I think Sunrise might be in here. Hollywood goes all the way down to North Miami Beach.
Yeah. So I would send it to Debbie Wasserman Schultz's office.
Exactly.
Okay.
And it should have an email down here too. Let me click on this, see if it gives me an email.
I'm on the Word doc.
Okay. So yes. So about services, contact over here, email me. And then I'm just doing it very quickly here.
No, it's fine. I just don't see your screen. I just see just the Word doc. That's all.
Oh, okay. 1 second.
Yeah, no problem.
Okay.
Okay, awesome.
Okay, and just to show you where I got this page.
Okay.
From this page. So it's this page to find your representative.
Okay.
Find your representative.
Got it.
And then that'll take you to this page where you type in your zip code and it brings up. I'm just going to go back on this one. So you said 33026.
Mm-hmm.
And it takes you to this page. And then you click on the email under the picture, and it'll take you to the representative's page. So you can I'd suggest mailing it as well as if people can afford the stamp. They can mail it as well as email it too. Make sure that they get it.
Mm-hmm.
And then you hit the email button here. Email me. Okay, so the people who are most supportive of this, unfortunately, I think Debbie Wasserman Schultz is with a party that is supportive of these enforcement actions, even though the delegation of authority, there's a question as to whether or not there are rules in place, especially for the cryptocurrency. So they've had rules put in place for enforcement for SEC, but what concerns us is the lack of rule making within the cryptocurrency, which is what is actually at the core of the issue with Neil's case.
Mm-hmm.
So it's not like they don't have a legitimate purpose, and it's not like enforcement is a bad thing. I wish they would have done it before the collapse of the housing market in 07. I wish they had done it in 99 when they had over-counter derivatives. It always seems that their timing is off. They're either day late or a dollar short, or they're doing it in an area that they shouldn't be doing it. That's actually having an adverse effect in. So, and but let me go ahead and get back to the letter. And we do have a congressional list that was created that also has similar information that we'll be also sending out, but these are specific to members. In other words, members of the the Financial Services Oversight Committee. So this is Ann Wagner. This is Bill Huizenga. District of Columbia is Maxine Waters.
Yep.
David Scott. French Hill, Tom Emmer. So there's some of his information here too. Yeah, there's some noise coming from outside this recording. 1 second. Okay, so that's another document. I'm not really sure what this is.
I actually don't hear noise.
Okay.
You talking about on your end?
Yeah, there was
Okay.
something in the background. Okay, getting back. All right, so and a lot of this will be read, but we also want to make sure that people CC or BCC a copy to this email address here, because what we're going to end up doing is keeping a record of it, of all the filings. So if it's ever asked, well, who sent and when did they send it, we have a copy of that. And then we can also forward that to others that we want to notify, concerning the issue raised by the letter.
That's good. And then at least they'll get some awareness that'll give them some traction and they can act on it. And I guess we should be able to like follow up with them.
Yeah. Yeah, we'll follow up on them, and I'll let people know about the results. And I wanted to point out that a lot of this is new to people, just like the petition. The petition was a new activity for most. Most people usually walk around, people with clipboards, when they see them. They don't want to give their opinions. But in this case, what we're trying to do is draw attention of people who think that there's apathy, that people do not care what's happening to Neil. He's on his own. So therefore, they feel comfortable to not do their jobs or pay attention to what it is that they're doing. So we want to bring attention. Even now, the petition has been got a lot of attention. We have, I think, last count was 1673, and it climbs a little bit. But what we really want to do is get those numbers up. Initially, we had discussed getting anywhere from 5,000 to 10,000 people, because that's enough to capture the attention of career politicians or people in law, in the legal systems, because they realize that you can fool some of the people some of the time and all the people some of the time, but you can't fool all the people all of the time. And that's what we're banking on, that people become more aware of what is being done around them, especially now.
Right.
Especially during this changeover. It's not just a simple recession or market adjustment. It's not, something that has been put out there as something that's going to happen and then disappear, and things will get back to normal. If people are under that impression, they're really not paying attention. And this is where we need to start paying attention, here and now with, and this is a simple action. It's a one-page letter. And we're just trying to get people to get as active as they can be, with this.
No, this is good. This is great, actually. Because I think there's like a lot of people who are like, that are asking the question, oh, well, when is this deal going to close? Or why does Neil not have, legal representation? What happened to his lawyers? And I thought he had lawyers. And, this deal's not going to get closed till next year. Can the deal close that Neil's still, in jail? Why are Neil's civil liberties being violated? What gives the courts the right to even think that they can get away with that? I mean, there's a lot of questions.
Oh yeah, and part of the reason. So this is just an action, but the real activity and information is being given out at the website. And let me just briefly go through that, and then to finish up on on this. Let me
sure.
bring this up.
Yeah, I mean, you have people who have come to their own conclusions. They just whatever they think is what is, and they don't know that there is information that has been collected by yourself and Kim graciously, that you've put together a lot of tangible, real proof, real concrete information that proves the legitimacy of the deal, right? The fact that it is actually genuine, it is real, and that Neil has not been really given a fair shake at this. He's just been basically being persecuted, in so many words.
Well, and he's been blindsided, because what he thought was going to happen is what he was used to happen. Neil Project. In the past, it was, a simple, showing up for a regulatory, hearing. He'd, listen to what their complaint was and what the resolution would be. I don't know why this is not coming up the way that it should be. And let's see. Okay, this is really weird. Hold on. In the past, he's had, agency activities, during the course of, whatever project he's worked on. But this is just totally different. Than anything that he's familiar with, because now they're coming at him with a complaint. but the only ones that should have been complaining would be his investors, and that would be settled in a court, dealing with commerce. That would be a tort suit. But because fraud was being thrown around,
Right.
and it wasn't thrown around by an investor, because an investor has a contract. So everything is shown in those terms, and they agreed to it. So it wouldn't be an investor bringing these charges. It would be a collateralized loan partner, which they don't have a contract with Neil. So Neil should not be the subject. And these are just simple differences that are not really considered. When people are hearing about this,
Mhm.
there has to be distinctions that are drawn and understood. And then there's a procedure. He has a due process, which is a procedure that recognizes his civil liberties and puts into place rules that take those into consideration. But there have been violations of procedural process or due process, which means a violation of his civil liberties, which is a constitutional violation, which above all, any proceeding is a bigger violation. For instance, the discovery status hearing was held without the defendant being present on the call, which isn't an issue. There's a status hearing. However, the 5,000 documents that were sent were regarding bank accounts. So when you do initial disclosure, there's what they call Brady material. And that Brady material has to be organized in a certain way. Yes, privacy is a concern. That means you redact the names and information of people who are not the subject, in the case. But at the same time, that privacy, the Brady material, that which is exculpatory or favors the defendant, has to be. It's not a request that has to be made; it's automatic. So it should have automatically been given. This isn't a request for information. This is what's required by law, and that did not accompany the 500,000 documents. So right away, what they're doing is they're pushing evidentiary or exhibits, evidentiary or documents that are evidentiary, having to do directly with proving a claim rather than supplying the documentation that's required of them. And that's an issue.
Okay.
And there are other issues that are going to be discussed, and then and the next newsletter I'm going to be including my analysis of overall, where we are, what the implications are. But first, we also want to put pressure on, the legislation. So the powers, three branches of powers. The legislative is where the people reside. That's us. That means that we have to push our congressmen, our senators, to do their jobs. And if they're already looking at these agencies, which they receive a delegation of authority from the people, from Congress, to do their job. But if they're not doing their job correctly, doing something outside of their delegation of authority, then we have to tell our congressmen to correct them. And that's what we're doing with this.
Got it.
Alrighty, so hopefully that is a clear explanation as to how to file the letters.
Yeah, filing the letters actually, that was pretty straightforward. That wasn't that's not challenging. That's not challenging. So that's not like I think just you answered it beautifully with where to go and how to go about doing it. And I think it's actually good that you are requesting, you know, carbon copies of everything. So you know who sent what, you know.
Right. And they also have a use later on too. And we're gonna get to that as well. So
okay.